Hello, as everything pops on here to Bridges Live, my host is Dr. Paul Dyer, and we have a show every Wednesday called You Be the Judge. You Be the Judge is a show that started with Marilyn and I to talk about legal issues around the world and the things that's going on, and a lot of things we just don't understand. So, what we have today, we have Judge Claudia Barber has joined our team, which I'm super excited about. And we have Mr. Joshua, who started Freedom Fighters. And we're going to get right into, he's got a case that he wants to talk about. And the reason why we do talk about these cases or these bills or anything that's in the Senate, because it affects us so desperately. It affects us so completely. And there's things that has gone on before. There are things that have been going on and will continue to go on in the darkness. So we like to try to bring things to light. Joshua, please introduce yourself and then get right into that case.
Hello, yes, my name is Joshua Hatch, and I'm the founder of Freedom Fighters based in Annapolis, Maryland. Today, I want to talk about a case dealing with a person who was wrongly convicted. This individual, because it's an ongoing case that's being litigated out in court, they ask that we don't use the names involved in the case, but we definitely can share with the community the scenario or the type of injustice which plays out in courtrooms, specifically the area in which this took place is in Baltimore City. Now, what's important about Baltimore City, if you go on to the National Registry of Exonerations, and this particular registry keeps track of those who have been exonerated in the state of Maryland. Once you filter the search, you'll see that Baltimore City or Baltimore pops up 31 times out of 40 for this particular list. And this list goes back to the 80s. Having created a culture where individuals are wrongly convicted based off of false testimony, prosecutorial misconduct, and the many other things which play out in today's courtrooms, I think it's important for us to look closely at this particular case. Now, I really can't do this case any justice in 45 minutes or to an hour. It's simply impossible for me to cover every aspect of the case. But what I can share with you in this short period of time is enough information that will cause you to wonder why this man has been sitting in prison since 1989. That's right. That's how long he's been locked up. 1989. This particular case unfolds in a Baltimore City street, a street that they call York Road. The state and the defense have two different theories behind this case. The state's theory is that two individuals who don't know each other somehow conspired to kill one particular person. The problem with that theory is that it's not relied on based upon what's been presented, the evidence, which is important in a criminal prosecution. The evidence would show that these particular two individuals who were accused of the crime did not know each other. Yet and still, this is what the state is alleging. The defense theory of the case is this: that the individual who I'm going to focus on today, who I'm going to call rightfully Freedom. Freedom was walking down the road with a friend. While he was walking down the road with a friend, there was a third person to have joined them. All three of them knew one another. Although the third person who joined them was close with the victim, who I'm going to call Vic. A person would come out the peripheral of the third person who was walking in the street. If you know anything about York Road back in 1989, the sidewalk was really, really narrow. You couldn't have 3 people on the sidewalk. So a third person would have to get out there in the street. This third person that was accompanying them, who later on would become a witness in the case, saw someone who I'm going to call, let's just say, misguided, walking up behind them. So misguided yells, "Hey, what time is it?" So the third wheel that was in the street, he looks down at his watch. By the time he could pick his head up to say a time, shots rang out. Now again, 6 shots rang out. There were 2 other witnesses that were to be called during trial. Some in which were not called but should have been. One witness says, as she was driving down the street, that she saw a commotion in the street. By the time she passed the commotion, which she thought was horseplay at first, a gentleman would fall to the left into the street. But as she was seeing this, an unattended child crossed in front of her. Now, she was lost. She was not from the area. And then to add insult to injury, a young child crossed in front of her. So now she's paying attention to what's in front of her, which is the child, but she's witnessing also as she's driving the events that are unfolding in the rear view. By the time she recognized that this was a serious matter that was going on and exited her car, parties had dispersed. There was yet another witness. This witness alleges that he saw what transpired a block away. So he's a block away. The events are unfolding allegedly in front of him, a block away. That particular witness gave several different stories.
Now, this was, Joshua, this was all done at the first trial, correct?
This was the events that the state
had
alleged to have happened.
Okay.
Right? This was what the state presented.
Okay.
Okay. And there was something which transpired, the defense attorney was made aware of. That is very important, and I want the listeners to grasp onto this. Early on, the defense attorney was made aware that the victim in this particular case was shot 2 months prior in January in the neck. And that the reason why he was, I won't say the reason then because I want to keep things in chronological order. Mm-hmm. But according to the victim at that time, although it was unknown to the defense up until this juncture, that this victim was actually shot as a result of the fact that he was testifying in a murder that he had witnessed with his own eyes. However, because during pre-trial stages, the attorney trying to come up with his theory as to what happened and his defense for someone who was actually innocent and wrongly convicted, he motioned the state's attorney's office to disclose all material pertaining to this investigation. But he specifically asked for any material or information that the state had in their possession that would prove that there was someone else after this particular victim. The only thing that the state produced was a police report back in January showing and detailing the events of what transpired with the victim, which was that he was shot and that he himself believed or understood the reason why he was shot. And he, at that point in time, was in fear of his life. Now, again, I'm going to say this again. And I have to say it again. The attorney for freedom requested all information pertaining to any other investigation concerning the victim. That was in 1989. Fast forward, trial. You have these witnesses that come forward. They're all the state's witnesses, not the defense witness. They're the state's. State's witnesses on paper. Their testimonies of the eyewitness accounts of what transpired, they don't coincide. Okay. Some testimony of what transpired doesn't match up with medical evidence. And I'm going to give you an example of what I'm talking about. If a witness say that they saw someone shooting someone from the front, but yet the autopsy report proves and shows that this particular victim had been shot from behind, then that statement was just now discredited with the autopsy.
Now, hold on, Joshua, and I'm going to go to Judge Barber here for a second. So far, what you heard, and there's more because he is going to get a diligent timeline review. When things are presented that way to a judge, what is? I guess you would have to speculate what that judge was thinking, but what are you thinking?
Well, it's too hard for me to figure out what to think based on what I've heard so far.
Right.
It's not enough. What I am hearing, though, is that I'm a little concerned about the part of the testimony where this witness was distracted by the person that crossed the street, and they took their attention to that. That would raise a red flag for me. But I don't know. The facts have to be developed more for me to weigh in further.
And then now I'm going to go to Marilyn. I'm going to ask her, would you? What are you thinking? And would you present something so wishy-washy that has testimony that doesn't even equal up to what you want to happen?
Well, I think that in a situation like this, you let the state present its case, and the defense then comes and plugs hole in the case basically, because I'm thinking that so far, based on what I've heard, what I would have asked is, how could somebody who is distracted with a child in front of her and she's looking at her rear view mirror to see this event, how this person could possibly be a reliable witness? But and I wouldn't be I don't think that the defense should even have to wait that long to present its case, because I think the defense should ask for a dismissal, because at that point I don't think so far, based on what I've heard, that the state would have met its burden of proving that this person is guilty beyond a reasonable doubt. But like I said, we continue.
Go ahead, Josh.
All the lawyers on there, I don't know if anybody wants to add in.
I'd like to add in a little bit more, and that is, this is why it is just fundamentally important who you have serving or presiding over the case as the judge. They're the gatekeepers, and they decide what's admissible evidence, what's credible evidence, what evidence to reject, etc. And you cannot, and I underscore cannot, have a judge on the bench with implicit biases, because when they operate with implicit biases, oftentimes the credibility of Black witnesses tends to be dismissed or disregarded, just like you see in everyday life, or they're treated as less than human, or automatically not credible. And To that extent, that's how you get into the bad domain of wrongful convictions. One of the things that I shared with one of the delegates is that I was concerned about prosecutors who failed to produce exculpatory evidence that leads to wrongful convictions. They should lose their pensions. I'm sorry. You do something like that and somebody spends time in jail for years.
And I think this is what's going on with
that?
yeah.
I'm sorry.
And
That's exactly what's going on here, man. That's exactly what's going on. Because as the story fast forwards, and I don't know how much time I have.
Oh, you got time. Go, boy.
Okay, as the story unfolds, when we look closer at the evidence that was later on discovered, and even the evidence that was produced at trial, it should have raised, for a good state's attorney, it should have raised the eyebrow on them and said, wait a minute, let's slow down here. First and foremost, let's deal with just facts. The fact is that the police department did not even take the opportunity to really investigate this. Within, I'm gonna say 6 hours, they figured they knew what was going on. Of course, investigation would ensue after that, but the investigating officer, who was later on questioned in post, was asked, did you look beyond what it is that was in front of you or what you were told by a witness right after the shooting? And he said, no, I didn't have to. I didn't have to investigate it. I had a positive ID. But you had a positive ID by somebody who had a motive, which would later on come out through further investigation, which, by the way, could have been done back in 1989, but was it done? And the question becomes, was it done consciously and maliciously? I would say it's up for one's opinion if it happened consciously back in 89. But once you've been put on notice that all of this mountain of evidence is pointing in another direction other than in the direction of the person that you have incarcerated, then now you're wrong, because you're consciously holding a man in captivity, knowing that it is evidence out here which disproved your theory back in 89.
Okay, and thanks, Josh. Because the one thing I know as a civilian, I'm always confused about when things are shown that the judgment was not a clear, concise guilty. Mm-hmm. Is there a reason why it doesn't get looked at again so often or more often or at all?
Well, I'm going to say the reason why it doesn't get looked at, and you have countless of cases, and let's just stick, let's keep it in its proper context. We just look at Baltimore City. There are countless of cases. I got 31 of them right here in front of me, where something transpired in this particular case where this person was not supposed to be in prison. You understand what I'm saying? Because there is a constitutional standard which is supposed to protect everyone. In this particular case, a defense has the right to defend itself. And listen, I don't have any licenses or degrees which tell me the fact that I have a right to defend myself. I have common sense. I understand that if you accuse me of a crime and you're saying that I did something, that I have the right to defend myself. And it is upon the state then to ensure that they uphold their constitutional duties and ethical duties to turn over this information to a defense attorney.
And they didn't turn it over. They didn't turn over the evidence.
And this did not happen. And
I'd like to add, while you're raising this issue of conviction integrity, I think it's very, very important that we as citizens, and especially through organizations like the ACLU and the NAACP, you should be having these state's attorneys come to your meetings and let them know you need a conviction integrity unit in your state's attorney's office, so that people with these issues can go there and revisit shaky convictions. It's imperative.
I agree with you, but even more to your point, I think that the community should have an outlet or a body above the state's attorney's office, which is able to summons them and question them on cases such as this one that are controversial, which they've had in their possession since 1989, and this man yet sits still 32 years later in prison. Because it's ridiculous how you can prosecute somebody, how you can find someone guilty, and there is 1, 2, 3 witnesses who don't have their stories together, the evidence does not cooperate. Then you have a ballistics expert. Let's talk about that. Let's talk about Joseph Caparo. This particular ballistics expert was in this particular case. There have been countless of cases that have come out which have discredited Joseph Caparo. I have one right here in my office right now from back in 2019, where a judge submitted a ruling which speaks to the credibility of Joseph Caparo and how he lied. I'm just going to say it flat out. I know that there's different legal terms to say, but I want the masses of the people to understand what I'm saying. So that he lied in several cases. And in this particular case, he perjured himself because when he was given under direct examination by the defense attorney, his testimony was that he recovered 6 spent rounds and that they had all the same grooves on these particular rounds. On direct examination, the attorney said, well, can this, and I'm paraphrasing, so if we ever get to release some documentation, I want you to know that I'm paraphrasing. So it was questioned by the defense attorney then, okay, all 6 of these shells then came from the same gun, one gun? His response was yes. Then on cross-examination,
Joshua, I'm so sorry to interrupt, but because we have a limited amount of time, and because, as you stated, there's evidence that seems to indicate that this person is not guilty of the crime that he was accused of committing. So can we talk about what he got as a sentence, and then we could talk about what he possibly
yes, ma'am.
Because we could go over the evidence for, it seems like a really long time, but there's nothing we could do about that. But maybe there could be something we could do on the back end.
And I disagree with you. I think it is something that we can do about it. And that is what I'm doing right now. First and foremost,
No, I think we actually agree, because like I said, we can't do anything about the evidence that was presented, but we can do something about maybe trying to get him justice at this point.
Yes, ma'am, I agree with that.
Talk about that, then.
And I think as a first step, justice looks like him being treated fairly like everyone else. When we have issues like this, I have more than 10 reasons right here in my office as to why this man should not be sitting in prison.
What was
10 reasons?
What was
10,
What was his sentence?
Life. At the age of 19, he was given life without the possibility of parole, plus a consecutive 20 years. Like the life without the possibility of the parole was not enough.
Wow.
Yeah.
Yeah, wow. That's what I said. So basically, a judge said that you're 19 years old. We understand that you just graduated high school. We understand that you are not old enough to purchase alcohol. We understand that you just have been the legal age to purchase cigarettes. We understand that you are not in a stable mind or position to actually really fend for yourself, not at 19 years old, but there's no hope for you for the future. There's no hope that you will can be rehabilitated. You are the worst of the worst, and therefore, since there's no hope for you, let me go ahead and give you this life without the possibility of parole. And oh, by the way, if you should happen to get out with that life without the possibility of parole, if that didn't cement you in there long enough, let me just add on a consecutive 20 years just to make sure it'll never happen.
So here's the question I have for the legal minds. It's not that he's 19, it's not the excessive amount of prison, but Joseph Capello, when you find out that a person has perjured himself and lied on the stand on other cases, wouldn't that give you cause to bring up your case that he also testified on? And is that enough to get it a hard look at?
Well, I'll tell you what I've read. I'm not going to tell you what is actually factual.
Hold on. Hold on. Go ahead, Marilyn.
Well, so much of it depends on what has happened and why. For instance, can we put any of it as new evidence or evidence that was not available back then? You can't go and retry the case because the time for appeal has passed, the time for reconsideration has passed. So the best that you could do is try to see if you could get a new trial because there's new evidence that was not discoverable back then.
So I have a question before you move on to my empty mind. What's the length before something can be retried? No, not retried, presented again. Because you said the time has passed. So he actually...
What I'm saying is that the time has passed for an appeal. This gentleman, Freedom, had 30 days from the date of his conviction to appeal.
And after that, that's it?
Well, and he did not. I'm assuming he did.
There is an opportunity to file a post-conviction.
Yes.
Yeah, but that time has passed too. You're talking about, him asking for reconsideration or post-conviction relief, and that time has passed as well. He's been in jail since 1989. Mm-hmm. But what we could talk about is maybe is there something in terms of is there new evidence that was not discoverable back then? Like for instance, you see it a lot in the wrongfully convicted rape cases where the person was convicted of rape because back then they didn't have the ability to do DNA testing and medical. It happens that new ways of doing DNA testing is then able to be presented. That person asks for a DNA test, and they find out that the person is not the person's DNA who was involved in the crime, and so the person gets exonerated. So that's what I mean by new evidence that was not discoverable back then.
So let me get this clear. I'm convicted of a crime. I'm going to say murder, shooting. And 30 days, if I don't get an appeal within 30 days, what's the next step again after 30 days?
You could ask for a sentence reconsideration.
Okay, and that gets denied. Then what's next?
And that, I'm saying, no, you have longer than 30 days to ask for a sentence reconsideration. Oh, and right now the time is escaping me, but
5 years.
5 years. 5 years. Okay, thank you so much.
It could be held on subcure for 5 years.
Okay.
Yeah, thank you very much for that. Yeah. So, but once those timelines have passed, there's really not that much that could be done, except, like I said, if there's new evidence that could not have been discovered during the trial. So, if for instance, Copero, I think you said his name was.
Mm-hmm. Yes, ma'am.
At that point, they did not know his credibility or lack thereof. Then we could talk about that. We could talk, it breaks my heart because, like they said, for everybody who's wrongfully convicted, there's actually a criminal who's walking out there. So, for our own public safety, we want to make sure that the right people get convicted, let alone the injustice of having somebody spend time in jail for something that they did not do.
But after 5 years, we're pretty much stuck in a hole.
Well, there's post-conviction proceedings for writ of actual innocence and things like that people do file. And also in this particular instance, there was not 1, 2, 3, 4, 5, 6, 7, 8. We get up into the 10 Brady violations with the withholding of information that was accessible back then, but that was withheld.
So is that new evidence?
No, that was evidence that was withheld.
Yeah,
was requested for by the
exculpatory evidence.
Most definitely. Brady violations.
Judge Barber, what?
That's called exculpatory evidence, and prosecutors have a duty to disclose exculpatory evidence, meaning evidence that will vindicate your client or that might lead to their innocence, that favors their client, that might question, reasonable doubt in a particular criminal case.
Now, is that considered new evidence, though?
It depends. Where's the defense attorney? Because if the defense attorney, well, actually, let's ask Joshua. I didn't mean to cut you off, Judge Barber, but I would like to know where the defense attorney is.
Okay, the defense attorney was there throughout the case, requesting and motioning the court for the very information that later on, 20 years later, fast forward time, an MPIA was done, which is the Maryland Public Information Act, which revealed that this particular information existed back when he put in the request, meaning that the police reports, the police notes, the internal notes, the actual statement from a witness that could have been called to corroborate a third-party defense, all was withheld.
So what do we do now at Minds of Law?
And this is not something that he's saying. This is something that we have black and white of. We got the documentation with the dates on it.
Well, at this point, because I guess what Joshua is arguing is that information in reference to the withholding of evidence and the Brady violations were not able to be seen by the defense attorney, and the defense attorney asked for the proper documentation way back then. He just wasn't given those documentations. One could argue that that's new evidence that you got.
Well, in addition to that, depending upon the jurisdiction, I know with certainty that the Baltimore City State's Attorney's Office does have a conviction integrity unit. Mm-hmm. And that's how wrongful convictions were overturned because people, chased Marilyn Mosby's unit staff down and got them to reopen old cases. And the Innocence Project, the solution now would be to take the case to an entity like the Innocence Project, or as Brian Stevenson has, EJI, Equal Justice Initiative, and let them work on it to determine all angles and all options that are available to this particular convicted defendant right now.
Oh, yes. Thank you for bringing that up. I forgot we were in Baltimore City. Yeah, Joshua, have you done that? Because like Judge Barber said, Marilyn Mosby's office has a specific unit just to do that. And she has exonerated people from that unit who were wrongfully convicted before. I think Mike knows about that because it's a point of discussion of his.
Yeah, so this particular case was actually referred to the Conviction Integrity Unit. However, it was a 50, because I don't want to misspeak here, but it's right here. Yes, it was a 54-page presentation that was given to the Conviction Integrity Unit. And from my knowledge, it was a 2-page response that was supplied by the Conviction Integrity Unit, all of which did not even address the issues that was contained inside of the presentation. The presentation was put together in order for them to lay out everything that was wrong with the case. Mm-hmm. But yet still you address that in 2 pages? How can you do that? It's impossible. So then again, we have the reason and the basis for the integrity unit to even be around, just like you said, is in order for them to look at cases where things have went wrong, where there's actual proof of a person's innocence. In this case, there is proof, but yet again, he still sits in prison.
So if Marilyn Mosby doesn't take it and they give a limited response, is they're basically saying by their amount of what they wrote that this isn't enough or to get to move forward on this? What are you guys thinking?
Well, I think at this, sorry.
Go ahead.
I think at this point, if her office has already looked at it and they haven't given the response that you and Freedom think justified, then it is a good idea to take it to the Equal Justice Initiative. You've already done all the work in terms of the 50-page documentation where you show why the evidence was insufficient to find the Freedom guilty beyond a reasonable doubt.
I'm gonna throw something else in this too. Not only was it the initiative of the attorney to look at this case, but also the Attorney General looked at this case and said that it would be a good idea for the Baltimore City State's Attorney's Office to revisit this case. But again, the only response that was given was 2 pages. And if we were to go through that and comb through that response, of course, because it's so much going on with this case. And when I say so much, we could turn this into an actual series, a television show, a movie if we like to. There's no way that you can address all the issues in 2 pages. And it wasn't even a complete 2 pages because half of it is your letterhead. Let's account for that, the date, your name, and all your titles and accolades, and then you start, dear whoever, towards the middle of the page. So it wasn't addressed the way in which it should be addressed, and it just looked like a rush job to me, as well as to both the attorneys that are involved. Incomplete.
Well, I think that, again, other entities out there, ACLU, the Innocence Project, Equal Justice Initiative, and every time I have an opportunity to, we have to be extremely appreciative and grateful for people like Bryan Stevenson, who created that Equal Justice Initiative. And I say this without shame. He should be on the Supreme Court today. And he should
get a Nobel Peace Prize, and he should be president. I mean, he should get all the accolades.
All the accolades. Mm-hmm. But that legal mind should be on the U.S. Supreme Court when criminal cases come before the highest entity where there's no other remedy at that point. Because he's seen so much, and he has worked on so many different state projects where people are wrongfully convicted and their sentences are overturned. So I mean, just mercy is very telling,
right,
and very profound.
So
in
Miller versus Alabama, I mean, that was amazing. Look at all these people who were given life without parole as juveniles, who are now being let out of jail because of that case.
So, Joshua, are you going to end up contacting with Bryan Stevenson?
Well, right now, his Freedom's attorneys are actively working on some post-conviction proceedings that could address some of these very issues that I laid out before you. But what I do want to say is this. Anytime that there is a culture that has been created where it's okay to convict someone, and you don't even have enough information or evidence to properly secure a conviction, then I think that's a sign of a terrible issue and problem that's going on.
That's called a dysfunctional system.
And I was gonna ask about that, because as sitting here, and Marilyn knows this, that what I'm so concerned about are all my black brothers and sisters who could be arrested. Like, let's take it from a car arrest, right? You don't want to argue in front of a cop out there by your car. This is not the time to argue, right? Mm-hmm. It's time to comply, because we don't know. We are trying not to get shot. Okay, so I comply. I get handcuffed. I get taken down to the police station. I am now read my rights. Now I'm still complying because I want justice to play out. But now they believe I did something, I'm unable to prove it, we go to court, it gets proved by shoddy evidence, right, that it's me, and I go to jail for 5 years. Now, I go to jail I'm sentenced for a longer time, but after 5 years, now it's almost practically impossible to get out of prison.
Well, I'd like to add that wrongful convictions is a serious matter because it's basically treating people like they're less than human. Mm-hmm. I'm just going to straight up say it. It is treating human beings like they're less than human. And that's from the prosecutor to the law enforcement, and judges, accepting, other people's testimony over the person that's impacted by the wrongful conviction. So these are issues that should be brought to the forefront. We should be in a posture where we are trying to correct wrongful convictions. And one way you do it is you make a deterrent there in the law for prosecutors to not release exculpatory evidence. It can't be, oh, gee, my bad. It's got to be greater than that. You've incarcerated somebody for years and put them in a position where you wouldn't want to be unless you want to serve a sentence.
Right. And that's what I'm saying. There is a culture that has already been created. And this traces way back to history, but I won't even go there. But I'm just going to say that there is a culture that has been created where people who are criminal defendants are not innocent until proven guilty. They're guilty until proven innocent. And sadly enough, a lot of criminal defendants, especially those confined within the urban community, are represented by public defenders. Now, I'm not saying anything bad about public defenders because I've run into some very good public defenders that did their job very well. However, because of the lack of resources that they have, because they are overworked and understaffed, because they are at a disadvantage and they're representing 100 clients at a time, criminal defendants do not get the type of representation that they would receive if, let's just say, they had $35,000, $45,000.
Let me add to that. Let me add to that. This, I used to host a talk show in radio decades ago, and Billy Murphy was my guest. And one of the things that stuck in my mind was that he said is that the system is not designed for poor people. That's what partially makes the system dysfunctional.
Most definitely.
Because if you need $1 million to get your liberty, it ain't working. The system ain't working. Just straight up and say it.
It's not.
It's built that way. But the same thing with people who are wrongfully terminated from their employment. They also face a similar situation where, some corporation can hire defense counsel and just outspend you and send you in a whole bunch of wheels and keep filing, motions. And at the end of the day, you might face jury nullification. And then that's another issue, in terms of, the integrity of the proceedings. And, you don't know if you're going to get an Emmett Till verdict. You don't know if you're going to get a George Zimmerman verdict. That's happened many, many times, based on the composition. Look, we've seen through both impeachment trials of a president how jury nullification works. You see concrete evidence right there, and those senators still voted to acquit the president. In those two impeachment proceedings. So you're dealing with issues like that that require more than just, a public defender's budget.
So let me ask you this way, because I too would pick on public defenders, and I, like Joshua said, there's some good, great ones out there. But here's the question from the legal minds again: how many defense cases? It probably depends on the type of defense. Can one person hold in a continuous? Like, is 100 too much? Is 5 too little? What's an optimum number for a single person to work? At a
specific period of time?
Yeah. Well, so, because I know cases sometimes overlap, right? They don't just go, you get it on the 1st, it ends on the 30th. Cases don't work that way, right? But how many cases can a human being work efficiently? And again, I understand it has a lot to do with some are drug cases, some are murder cases. But if we don't put a cap on this, then we're always going to overwork the public defender. And knowing that they are overworked, I don't. So how is this rectified? Like, because my ex-wife is a social worker, and she had to. And when she got to management, she got the city to hire more social workers because her caseload was just too much to go do child protection surveys. You just can't go to all these houses. So
that's a realistic comparison in the sense that, and I think the answer really has to do with, are your managers effective? Whoever is managing public defender cases and case loads, are they doing a good job of it? And are they shifting cases when the load or the intensity of the case gets greater than anticipated? Because oftentimes, trials could, a 2-day trial can turn into a 5 or a week trial, 5-day trial or a week trial. And then you've got to adjust your caseload accordingly. You can't be 50 places at one time. And you can't be cutting your time off and, shortchanging somebody, a felony murder case, because you've got, 10 other court appearances the same week, and you're not able to finish off on your motions or, your critical or substantive aspects of the case, even, the detective work and making sure that the evidence is in line for each of these cases. So it's a management question, and it's about hiring the right manager and giving them the right tools so that they can make the adjustments as necessary when the case loads become greater than what's humanly possible.
And I would agree with that as well. I want to say two things, because since we keep quoting Brian Stevenson, I saw his quote about, where he says, quote, "Our criminal justice system treats you better if you are rich and guilty than if you are poor and innocent." And I think that's just such an eloquent way of saying what we talked about before. And
that's a shameful statement to say, but yes.
Yeah.
It's a shameful statement to say.
It is. And I think Joshua said $35,000. I don't know of any lawyer who would touch that case for $35,000. I see 6 figures or nothing.
Most definitely. And that's the position a lot of these guys are in. They don't have someone that can actually advocate on their behalf. So they're stuck as pro se litigants. And you and I both know how pro se litigants get treated. It's a disrespect to the court when you actually are presenting a motion or trying to defend yourself in court, and it's not done so by an attorney. But in this particular case, and I have to keep pointing my attention back to this, only because of what I've seen, only because of what I read, only because of what I watched. It is sad. It is so sad that there is all of this evidence, all of this, a conspiracy plot to kill the victim in this particular case, unrelated to the person who they have incarcerated. Mountains of notes and police notes and prosecutors' notes and information that was requested by the defense attorney that was not given to him. A ballistics expert that was discredited widely by several different judges in several different courthouses. Why is this man still sitting in prison? 1, and 2, why hasn't it even really been taken back to court and taken through the proper channels to release this man? Why? Because you and I both know it's a money thing. It's a money thing. At the end of the day, yes, I understand that they have a conviction integrity unit, but the fact remains is that it's more than just him.
But see, that's the reason why the work that Brian Stevenson is so significant, because his Equal Justice Initiative project, number one, probably by this time is well funded, because it's been around for years. But to the extent that you run out of money, which is a real issue for, especially for people practicing criminal defense work or to the extent that you have a victim. If you remember the movie Just Mercy, the first time he filed a motion to reconsider that conviction, the judge still did not grant that in that movie, which was a real story based on a true story. He had to go back again and get a new trial, and invest the time in a new trial before he actually was exonerated.
And Joshua, is this where you see this going? He's got to get a new trial.
He's going to have to get a new trial. That's where it's going. But at the end of the day, even with the new trial, the state's attorneys, they're not stupid. In this particular case, there was 6 bullets involved in this case. When you retry the case and, in a homicide case, you're supposed to hold evidence indefinitely. In this case, mysteriously, the bullets are missing. They're gone. Right along with Joseph Capero. So there are so many things in this case that would scream loudly if you re-prosecute it. You're going to lose.
So would they re-prosecute a case they don't have the original evidence for?
That's up to the state's attorney.
Gotcha. But he wouldn't do it, would he? I mean, he or she?
Probably not.
Probably not.
And
Probably has to be not. Sorry, a new trial has to be ordered first. They're just not going to file any papers in the court and say, "Oh, let me retry this case." So, Freedom would have to go through the first step, which is get a judge to order a new trial.
Yeah, that's true, and I understand that, and that's part of the problem. My thing is this. It's really simple. You all can utilize the legal terms. I like to utilize common sense, and this is no disrespect to anybody. If the defendant was supposed to have the information initially while he was going through trial, then he should be allowed to go back with that information that he was supposed to have during trial and get retried with the information that he asked for initially.
It's not to be a Debbie Downer, and I don't want to use Debbie as a bad name. But as a state's attorney, I'm not retrying this case. And who can force me to retry this case?
Well,
the court can.
Go ahead. In the movie Just Mercy, remember, it was the prosecution after he figured out that the defendant was innocent. He dismissed the charges, so the prosecutor has that option too.
Moved
to dismiss the charges, and the court granted the motion.
There's more that we're going to talk about this next Wednesday on another court issue. But I want to ask a couple of people around the room. I don't know if you're attorneys. I know the judge over here is. But Miss Lisa, what are your thoughts? I'm going to just go around the corner here. From just hearing what you heard, and that's all we can go by. What is your feeling and what's your thoughts?
I'm a social worker and new to the criminal justice piece. I was invited by Sarah Coleman, my partner, that we're partnering up on some things. The system is irreparably broken, and it's irreparably broken on so many levels that it's hard to know where to start. And the thought of someone sitting in jail for 30 years and nobody has to take responsibility for that, and there are no repercussions for the people who put them there. It's a loss.
There's no words for it. Yeah, there's no words for it.
No, there isn't. And he's my age, and I think about 19, I think about where I was at 19, and I think about where I am now, and he's lost almost his entire life at 19. And who in this room could sit there and say at 19 you made the best decisions that you made, and this is an innocent person.
All right, Judge, I'm going to get to you last. Salama? Did I pronounce that right?
Is it Salima? Or you muted?
He's muted. He's trying to unmute.
Okay, I got it. I'm sorry. That's my daughter. I'm sorry.
Okay.
So I'm actually with the Annapolis Police Department. I'm Officer Robert Horn. I'm actually new to the Annapolis Police Department. I retired from Baltimore City Police Department. I spent 26 years with the department. So I actually, for about 15 years, I ran a reentry program for the police department. So I worked inside the correctional facility doing reentry, helping returning citizens to reenter back into the community, putting them into programs and workforce development. And I'm also a chaplain with the Department of Public Safety. So I became a volunteer in 1998. And I'm from Baltimore, born and raised. And, I was invited by Josh to come on today. And it's one of the reasons why I became a police officer, because I understand that the system is really broken, and it has been for a very long time. So that's what inspired me. When I graduated from high school, I went into the military, and I come from West Baltimore. And so a lot of things that has just been happening in history just really motivated me to join the department to make the change. My entire 27 years and what I do in Annapolis is the same thing. I do reentry. I work for Chief Ed Jackson. And we're working with the population, and we're working with the community to better relationships, to build trust. And I know it's very difficult because of just historically what has happened in underserved communities. So I understand. And so, but it's because of the relationships that I've been building in Baltimore and now in Annapolis. I've established that trust not only in the communities in Baltimore, but within the prison system. That's both federal and state correctional facilities. And so a lot of these men that you're speaking about, I know them. And it really breaks my heart, because I say to myself, that could have been me. I could have been that person. And I'm very fortunate to be where I'm at in my life. Mm-hmm. And the fact that I wasn't one of those persons that was wrongfully convicted or accused of a crime that I didn't commit. And I have been stopped by the police when I was a teenager. And I was taken into custody for something I didn't do, but I'm just fortunate that it didn't escalate and I was charged with something. So I'm a part of the solution. We have a long way to go, mm-hmm. and I'm glad that I was invited to this forum today. I really wasn't sure what was taking place today. So I'm just here. I'm here to support and to try to make things better. So and I'll stop right here.
Michael, what do you think of what you heard so far? That mute buttons, it's got to be bigger. We got to develop more computers.
Okay. Well, I turned 79 this year, and I've been around a long time. It's a racist system. There's no question about it. I identify former Officer Horn with some of what you say, not that much of it because of my privilege, but I did grow up in a low-income housing development in Brooklyn. And I know what happened to a lot of friends, and I know how the system's rigged. In my case, I've tried to clear my conscience by being on the side as much as I can of people who have not done well with the system. So, starting in '64, I was doing voter registration in the South, and last year I was arrested with Jane Fonda on a climate change action at the Capitol. And every time I hear Claudia and every time I hear Marilyn, I mean, my heart goes out. I want to do what I could do to help. But it is a rigged system. It really is. And it saddens me. And when I hear Josh talk, I just know maybe I've done as much as I could do, maybe not. I am supposed to talk with Will Smith, Senator Will Smith, this evening. I just want to know if he's come around in terms of the amendments he added or anything else, Marilyn, in terms of things that he was not doing to help.
Mike, you asking me specifically because I have not heard anything yet in reference to any movement. So you're probably ahead of me on that point.
Well, okay.
All right. And Judge, you have anything you want to add to that?
I thank you for inviting me again to the program. Very interesting issue, and I hope it mobilizes us and gets us thinking into having some type of legislation presented and making sure that we reach out to legislators and let them know of these deficiencies, and that there should be a deterrent for prosecutors who cause wrongful convictions because of exculpatory evidence that is not revealed to the defense as it should be. And to that extent, you've got to have a deterrent mechanism in there to deter prosecutors from cheating and being dishonest. And there also has to be legislation to have an automatic review of cases in which law enforcement may have acted or may have perjured themselves. Just straight out say it. Because those cases need to be revisited, because we're talking about justice. No one needs to be sitting in a jail cell and they don't belong there because of an injustice, and somebody lied and accused them of something they didn't do. Nobody wants that. Everybody should be cringing when they hear that.
As a public, how do we put pressure on what and on who to get this heard, retried again? How us as citizens, caring citizens, how do we help wrongful convicted people be heard? How do we do that as a civilian?
Well, I think that we can put pressure on, as I said before, the state's attorney, even writing them even now and saying, hey, you need to revisit this case again. But more importantly, if that effort failed, then we still need to address this with entities like Equal Justice Initiative and the Innocence Project. But as I said before, at the same time, we need to make sure we are heard and we vocalize our thoughts with legislators who can change the law to make our dysfunctional system more functional.
I think Mike wants to say something.
Yeah, the last thing you said is very important. We have to know who we elect on the delegate level. Obviously in my case, I think of Lorig Charkoudian. So Lorig is one of my reps in the 20th district. She's very involved in trying to make things better in this system. And I'll call her tomorrow ask her if she knows anything about this case. But you've got to know who you put in power. So in my case, it's David Moon, Lorig Charkoudian, and Janelle Wilkins, and Will Smith. You have to know who they are, where they stand. They've got to hear from you. They can't hide behind innocence themselves. That's being guilty. But you're responsible for knowing who they are, because they're the ones that are supposed to represent justice in the state.
All right, family. We're coming to a hard break. I just want to thank everyone coming on You Be the Judge. Thank you, Judge Barber. Thank you, my partner, Marilyn Pierre, for coming on You Be the Judge. We are here every Wednesday to talk about legal issues, court cases, and things just to understand the law. Because the more we understand, the better we are strengthened with our power, and more we can pull together as human beings. You can find all the shows on iHeart and where you catch all your podcast channels. Just look up Bridges Live with Dr. Paul Dyer. You Be the Judge, and you will find it. Thank you so much. Marilyn, anything before we take off?
I think this was a great discussion. Thank you, everyone, for joining us. I hope that you will join us next week, Wednesday at 6 p.m., so we could continue this discussion.
Thank you.
Excuse me.
Yes.
I'm sorry, my face is not on there, so I've been trying to get y'all's attention. I almost gave myself an anxiety attack. This is Sarah Coleman. Joshua, Lord have mercy. I'm telling you, I almost passed out over here. I had a Joseph Copera case myself. I'm an advocate from Frederick, Maryland, and I don't have any type of law degree or anything like that. You guys are trying to ask what can be done. Let me tell you what I did in the Copera case myself. I searched up, well, I won't say the state's attorney, but it was the state's attorney in Washington County. I learned everything that I could about him. On Joseph Copera himself, I found out, through Michelle Nethercott, how he lied about his credentials and all this bunch of stuff. I myself, because I went to an attorney was going to try to charge me $27,000. I have a 7th grade education. To the glory and grace of God, you understand what I'm saying? I went down to the courthouse and I found similar cases, and I put together a writ of actual innocence myself. I went to the state's attorney in this person's case. He knew for a fact that the person it wasn't a debate about his innocence or anything like that. The thing was, the state's attorney had not vetted their witness.